I figure if this doesn't get people going into the vlog, if this is not the best way to start a live stream, I don't know what is. All right, and I hear myself. Let's get everything going here. I see a commercial, skip ad, and I see my face. Okay, perfect. Now, I'm gonna bring down this window just so I can see the chat as we go along. Okay, give me 1 second here. Like this. Yeah, I'll have to get smoother on getting this set up, but I think so far so good. I just want to see the chat as we go through. I'll forget it. I don't need to see my face. Okay. Are we live? Can I see the chat? Oh, you know, sorry, hold on. I got to get framed properly. That was what I was trying to do. Let's just get framed while everyone starts to trickle in. Framing. There we go. Let's just satisfy the OCD a little bit. Everything is symmetrical. One finger width, good. Straight lines, perfect. Okay, minimize, get to the questions, and maximize. Okay, we're here. Happy Saturday, everyone. Okay, while we let people start to come in slowly, 63. Okay, it's getting there. Nice, my first live, Sleepy 1208. Nice to see you. I'm going to try to look at the green light and not at the chat section. Okay, and while everyone comes in, we'll lay down the rules again. No legal advice. Nothing in here is legal advice. We're going to talk about the last few vlogs from the last week or two. Last week we did a live, but it was a live with Nick Recchietta from midnight my time to 2:40 in the morning, which... I'm not as young as I used to. It took its toll for quite a while. We're going to start with FUCT, and we're going to go into a little more detail and a little more, I say possibly nuanced discussion just because it's live and we can delve into certain nuances that may not have been totally clear from the video based on some of the comments. We'll go into 230 of the Communications Decency Act, maybe talk about Hawley's, is it Hawley? It's Hawley. Hawley? Oh, the Congressman's proposed modifications. I will get to all super chat if I can, but to respond or to modify in light of some critique from the Oberlin live stream, I'm going to deal with a topic, then start to do some questions, then go back to a topic so there's not too much bouncing around because it's sort of the way my mind works, but some people think it might be a little distracting to the overall live stream to bounce in and out to get too many questions. But while we see the number going up of people coming in, let's just see if there is any questions that we can start off with while we let people show up. What time is it now? 3 minutes. Yeah, we give them like a good 2 minutes. I can see you. Vlog Dog is always a win. Well, let's get him up here if he's going to do it. Booyah. Here we go. Sup, dude. Hello, people. Brian, Judith, Scott. I have slow mode on for 20 seconds, and that's just so that we don't lose track of what's going on here. Yosemite Sam says he's been framed. We'll need more details. Carly Shelton says, Viva, let's fry YouTube. Let's not. That can be misunderstood. I rock Z Speed. Thank you very much. I believe we have our first super chat of the day. We got Ginny Thompson says, Barney. Okay, and I think we have let people come in for long enough. I rock Speed says he loves the channel. Thank you very much. YouTube has been messing with many channels. Yeah, we'll probably get to that by the end of this live stream as well. But we'll start with the linear, topic-oriented subject matter. I may be on a hard 1 hour because my wife is with the kids at the local pool, and we don't know how long it's going to last. It's midday, and the sun is strong. Okay, is this legal advice? This is not legal advice. Not legal advice, especially since I don't even like constitutional law under Canadian law, but for some reason I find it a little more interesting in American law. Okay, FUCT. Has everyone seen that vlog by way of Y or Ends, my last vlog on the FUCT, which was the follow-up on the initial on-location analysis in Washington, D.C. It's a very cool thing. It's like one of those lawsuits where it's not even about the specific question anymore. It's about the broader issues of the constitutionality of the provisions of the Trademark Act or the Lanham Act. The Lanham Act, it's L-A-N-H-A-M, is like the 1950s act, which is the Trademark Act, and it governs what can be registered by way of trademark. And it's interesting. Yes, I was wrong for the right reasons. I was wrong because I was too myopic in the question that I was addressing in my own mind. I was also wrong because the good thing about this channel is I get to actually learn more about the stuff that I'm doing topics on, and I learn a lot from the comment sections as well, and people who know more than I do, the filtering up of the information on the internet. Mattel versus Tam was the decision that occurred in the meantime, which changed things. But starting from the beginning of FUCT, for anyone who doesn't know what it is, and I'm saying it like that as a joke just so that I'm not repeatedly using a blasphemous term on my channel, but then the joke is that, you know, Scottish people hear FUCT for actually what it is. It's FUCT, man, yeah. So starting from the beginning, the FUCT brand was founded in 1990 by Eric Brunetti. Brunetti or Brunelli? Brunetti, I believe. And it was streetwear, and it went on. It was streetwear that got very popular. Skatewear, urban wear got very popular, and they decided ultimately to apply for registration of the trademark in 2011 because of the amount of knockoffs that were appearing on the market. And we've discussed it briefly in other videos, but there's a difference between common law protection of a trademark, which exists just by virtue of using it, versus registration trademark. And the common law protection doesn't offer the same benefits or the same protections as registration. Generally speaking, it's geographically limited based on sales, so it's not nationwide if your sales only occur in, say, California or New York. There's overt benefits to registration of a trademark, such that it's something that you should think about doing because it creates prima facie evidence of the validity of the trademark. It creates nationwide protection. You have certain legislative recourses in the event of trademark knockoffs. And incidentally, I think it's been long enough. I won't mention names, but I can actually mention this lawsuit that I was involved in because it was public in any case. And it was for a restaurant that operated in Montreal, and it had a very unique name and a unique spelling and unique font. And overnight, we discovered that there was a restaurant operating 3 kilometers away that had literally taken the exact same name for the restaurant, for the trademark, changed one letter from it, used the same font, and more egregiously copied the menus from off the internet, literally reprinted them, and thought that, you know, what they were doing was okay because they were far enough away and they had changed it a bit. Under the legislative provisions and the recourses that we had, on the one hand, we sought statutory damages, which were provided for by law, which do not require actual evidence of actual damages. But the coolest thing is that we were able to seize all of the materials containing the copyright infringement or the copyrighted material on the basis that it was ours, that had been copied without the right, and therefore we could just grab it all up. And so you have these legislative protections that exist when you register a trademark that you don't necessarily have when it's just common law protection. So there's a benefit to doing it. FUCT trademark was rejected by the USPTO, the PTO, the Patent and Trademark Office in the US. They appealed that decision and it was confirmed, and they ultimately took it to the Court of Appeal, who sided with FUCT and said that the provisions of the Lanham Act were unconstitutional in their scope. But what had happened in between that was that you had this trademark lawsuit involving the Asian rock band called the Slants. And I suspect everybody knows that, correct? But anyways, you should have known that. There was an Asian rock band called the Slants, and they registered for trademark of their band before the Supreme Court rendered its decision on the FUCT. And they were contesting the constitutionality of the limitation of registration of trademarks on disparaging marks of living or dead persons. So you imagine the Lanham Act contains a provision for what is able to be registered by way of trademark and what is not. And the things that are blocked from registration are trademarks that are confusingly similar with existing trademarks, trademarks that contain flags, official emblems, trademarks that are purely descriptive, like wet for a water bottle or soft for, I don't know, a condition or something, but purely descriptive terms cannot be registered as trademarks. The Slants were contesting the disparaging of persons living or dead portion of the Lanham Act restriction on trademarks, and they were contesting it on the basis that it was contrary to the First Amendment because it discriminated based on viewpoint. And this is the part of my initial vlog, I think, that was not particularly, that may have been a little bit too nuanced, and I didn't go into sufficient detail. The viewpoint versus form discrimination, which is unconstitutional. And it was argued that the provisions of the Lanham Act forbidding the restriction of disparaging marks was viewpoint discriminatory, in that it would not give a trademark to something that the PTO decided was negative and disparaging, but it would give something good, it would give protection to something that was flattering or that the PTO agreed with. And that was the discrimination based on viewpoint that was at issue. And the Supreme Court was divided to some extent on the judgment, but unanimous on the fact that viewpoint discrimination is presumptively unconstitutional. When the government discriminates not based on the form or not based on the content, but rather on the viewpoint being expressed in the mark, it's presumptively unconstitutional and therefore contrary to the First Amendment. So that's what happened with the slants. It was determined that the provision of the Lanham Act dealing with disparaging marks was unconstitutional because they allowed things, and these are actual examples. I think one was called celebration, and another one was they allowed a mark for Asian efficiency, I believe was one of the marks that they authorized, but they didn't authorize the slants because they literally went to the Urban Dictionary to determine that the slants has this negative disparaging connotation. So the disparaging portion of the Lanham Act was struck down in the slants. Come FUCT, who argues now not necessarily that FUCT is, proper, or not necessarily that it's even to be liked, but that the portion of the Lanham Act, the Trademark Act, that the PTO used to refuse registration was viewpoint discriminatory, in that they said it was immoral or scandalous. I mean, that was the criteria under the Lanham Act, that they could refuse, the PTO could refuse registration of a mark if it was deemed to be scandalous or immoral. And the Supreme Court said, yeah, that is necessarily viewpoint discriminatory or inclusive of viewpoint discriminatory. And this is the nuance, is the PTO, and tell me if I'm talking too fast. Someone say yes if I'm talking too fast in the comment section. The PTO said, FUCT is objectively obscene. The Supreme Court said, yes, but you have authorized marks which say, dare to say no to drugs, while refusing marks such as you can't spell healthcare without THC because it was scandalous and immoral. And so they said it wasn't just a question of form. As drafted, the Lanham Act includes marks that are offensive in form or, in form, but it also includes marks that are deemed to be scandalous or immoral in the viewpoint that they express. And that was what it all came down to. The PTO basically argued it's not unconstitutional as drafted because it includes the FUCT, although it incidentally sometimes gets the you can't spell healthcare without THC, which is viewpoint discriminatory. And apparently the PTO basically argued that those were all accidents, but this one was, properly applied. And the Supreme Court basically said, look, it contains viewpoint discrimination. It doesn't matter that it also encompasses objectively objectionable FUCT in form. It targets and includes viewpoint discrimination, which is presumptively unconstitutional, and therefore Congress, you want to include the word FUCT, but you don't want to include ideas and expressions of viewpoint, redraft the provisions of the legislation. And so that's it. It was very interesting. There was one issue about viewpoint discrimination versus content discrimination, which was the idea that there could be limitations depending on the circumstances on the First Amendment. Say, like, you can't report on certain subjects was one of the examples. You can't report on the Iraq War. That would be content-based discrimination, versus you can't report negatively on the Iraq War, which would be viewpoint discrimination. And in order to justify content discrimination, you have to have some pressingly valid reason to justify it, versus viewpoint discrimination, which is presumptively unconstitutional. So that is how they got to striking down those provisions of the Lanham Act. And the entire judgment reads as an invitation to Congress to go back and redraft this provision if what you want to do is only capture the FUCT but not viewpoint. My prediction, I forgot to put it in the video. I mean, I predicted in the first video, but now that this is the case, I'm predicting that we're going to see an influx of applications for swear words now. Like, I'm just predicting that we're going to see this because officially the portion of the Trademark Act banning scandalous and immoral marks has been struck down. There's nothing preventing it, and there's nothing that would justify the refusal of granting the mark. So we'll see what happens. I mean, I suspect that might be the impetus to get the government to act quickly if they were not so inclined to act quickly, because you're going to get an influx of people trying to register all sorts of offensive marks that are offensive in form but not offensive in expression of idea. So that's basically where the FUCT decision came in. And there was one other thing. I'm going to go now and see if I have missed any questions here in the comments section. If anyone wants to put back in a question now, now would be the good time. But it is very interesting to see what happened with that decision, because it was a question that was beyond the term. It was a question of the constitutional validity of the restrictions. And one of the judges, and I think it was Judge Roberts, raised an interesting point, which said, you know, it's not a First Amendment issue because you're denying a benefit, you're not preventing them from freedom of expression. And this was something that I had touched on in my original video as well. You're just denying protections under the law. You're not preventing free speech. But the flip side to that, and it was addressed in the majority opinion, I believe, is that you imagine saying that you're going to give government benefits to certain people but not to others because you disagree with their viewpoint. I mean, that is unequal application of the law based on a viewpoint discrimination, which seems on its face and presumptively unconstitutional. But so that was it. That was the FUCT was fun to watch. It's fun to be wrong, because even when you're wrong, you can learn from your mistakes. And I say I was wrong for the right reasons. The judges basically said FUCT is not something that we would endorse, but you're not asking the government to endorse it by granting a registration of a trademark. You're just asking the government to give certain benefits without discrimination based on viewpoint. So it's very interesting. And then I think most people, let me see what we're doing here. Most people, I think, also wanted to talk a bit about Section 230. So let's see if there are any questions on the trademark before we move on to the next one. Was the decision to, this is Keith Wagner saying, was the decision to call them Vlawgs one made knowing the flowing feel to vlog dog, or was that just a very pleasing, happenstance? My trademark is still pending. So trademark is still pending. It takes like 6 to 8 months to get an answer. The vlog dog, the vlog itself was a happenstance suggested by a subscriber who says, dude, don't say vlog, say vlog, VLAWG. I was like, that's great. And we started doing it like, I think it was October 2017. The vlog dog was also just another one saying, nah, dude, don't spell it dog. It's vlog dog. He's up there. And it flowed. It made sense. Now, I don't think I actually have to try to register vlog dog because it includes the vlog. So I'm not going to like just start flooding the PTO, or what we call in Canada the CIPO, with trademark requests. But I also just want to get the essential vlog and not worry about the rest after that. 3 steps sideways says, think they will make form more expensive to trademark. More expensive. That's interesting. I mean, I don't know that, I don't know how that would materialize, where you'd have to then have the discretion as to offensive in form and then charge them more. That might be, that seems like it could be also unconstitutional in terms of charging certain people more for certain government services for, call it viewpoint or discrimination-based ideas. I don't know. I think the solution is just going to have to be more clearly defined restrictions that don't admit of the possibility of, and the historical examples of the PTO refusing trademarks because they've deemed expressions of ideas to be offensive, like drugs, or there was some, anything with critical of religion was refused, but things that are positive get the go-ahead. So, I mean, it's going to be interesting how to redraft it properly so that it's compliant with the First Amendment, and that's what Congress should be doing in the normal run of things. But politics is what it is today. If there's other fish to fry and other fights to fight. A. Joe says, how am I going to celebrate 100K? I don't know. I think my wife had some ideas. Maybe we'll like do a road trip to Canada's Wonderland and sneak the GoPro onto some of those rides out there. I don't know. Maybe just a deep breath, and a good night's sleep. It's been. I mean, it's fun, and this is like stress, and it's always, the wheels are always turning in terms of the pressure and the feeling that you want to keep people engaged and keep dealing with interesting topics. Dees Nut says, you will be covering the reasons the Supreme Court kicked back at the question of the census. Oh, so I don't know that I can, I mean, that's a very, very complex issue. I was there actually the day that was being presented to the court in Washington. I'm going to look into it. I'll see if I can do it. It might be something that I think might be a little, say, it might be, if I don't have a sufficient understanding of it, I wouldn't feel comfortable covering it. I'll see if I can do it. It's definitely on the to-do list, but I still need to get to our decision about Mike Ward being fined $42,000 for offensive jokes by the Quebec Human Rights Tribunal. Okay, so that was the FUCT. If anyone has any more questions about that, to the extent that I can answer them, it was just an interesting, it was a very interesting decision. It wasn't as lengthy as I thought it was going to be, and even when they disagreed, the judges sort of agreed. It was not real dissent that were diametrically opposed views. A lot of people were saying that Roberts, who says that we're not supposed to redraft the law so that it becomes constitutionally compliant, may not have followed his own advice in the Affordable Care Act Supreme Court decision, which I haven't read, and that might be too partisan even on its face to deal with, but we'll see. Maybe we can do that. Scott MC says, Lanham Act requires that service names are not protectable if the words it contains are functional. Could that be said of Vlawg? So that's it. Purely functional, purely descriptive terms, yes, but no, I think Vlawg is sufficiently transformative and original, a variation of what the Vlawg itself is and was, that I think I'll get it. I mean, I think I'll get it. It's the description I gave to it also was sufficiently limited to what it is, like video-based law videos, you know, so it is the play on Vlawg, VLOG, which would not be trademarkable, versus the Vlawg. I think we'll get it. This is Taylor K. Any advice for an aspiring lawyer still in school? Suck it up, and plug through it, because law school's hard, but the first years of practice are even harder. It's like a badge of honor. You got to do it. You got to get the experience so that you can then either decide to stick with it or move on to other things. What else do we got? I think we covered everything on FUCT. Let's talk about this 230, Section 230 of the Communications Decency Act, and immunity, the losing immunity, whether or not YouTube's a platform versus a publisher. That was a vlog I did last Saturday when we were in Ottawa, and that's something that's amazing and that's going to come to a head very soon. So let me remember the time. It's about 22 minutes in, and I'm going to timestamp this in the comment section so people can skip to whatever sections they want to watch. Section 230 of the Communications Decency Act is incredible. And let me read my notes, because I took a screenshot so that I can properly explain what it is. Where is it? I seem to have not. Oh, here it is. It says, no provider or user of an interactive computer service shall be treated as a publisher or speaker of any information provided by another information content provider. So Section 230 of the Communications Decency Act is what gives immunity to these big platforms so that they are not held liable for the wrongdoings of their users. And the history behind it is very interesting as well for anybody who doesn't know it. I sort of went into it to some extent in the video and the vlog I did on it, but not in too much detail. It's always the 80-20 rule or the 90-10 rule. There was a decision in 1991, which was the CompuServe decision, where CompuServe was a hosting platform, and they didn't do any sort of moderation, deleting stuff or removing users or banning users based on content. They just let everything go up. And there was an issue. I don't know the details offhand, but they were sued, or someone was trying to hold them liable for defamatory statements, I believe, that were on the platform. Their defense was, we're just a platform. We don't moderate. We don't edit, and we don't editorialize, so we can't be held liable for it. And the defense was held. And then, like 5 years later, there was a case called Prodigy, where Prodigy versus an investment banking firm, where defamatory statements were made about the investment banking firm engaging in criminal conduct, going into an IPO, an initial public offering. And Prodigy invoked the CompuServe defense that they're just a platform, they can't be held liable for the defamatory statements made by their users. And the court came to the conclusion that because Prodigy, had engaged in moderation, that they basically acted as a publisher and not as a platform, in that they became, by virtue of their moderation, removing stuff and allowing other stuff, they became liable for what people were saying on the website. And it sort of had the counterintuitive result of actually imposing a higher burden on people or platforms that were attempting to moderate versus those that were not attempting to moderate. And so, what ended up happening is that was 1995. In 1996, that's when they created the Section 230, which basically said that the platforms are not going to be held liable for the wrongdoings of the defamatory statements or whatever of their users, in order for the platforms to moderate without feeling like that they would get penalized for their moderation. And then, you know, we have gone to where we've gone now, where the question then becomes, in the moderation, has the moderation become editorializing? Has the moderation become politically, ideologically biased to the point now where the platforms are no longer just moderating to keep out the criminal stuff, the defamatory stuff, the illegal stuff, but they're moderating to keep out certain ideological stuff? And if they are in fact doing that, do they then lose their immunity because they are not just moderating, but editorializing? And we know where this has gone now, and we've seen the undercover, the investigative journalism that the Project Veritas came out with. We've seen the congressional hearings now, Ted Cruz, and I always forget his name. Someone's gonna remember his name. Whatever. So the discussion now is, are these platforms losing the immunity under 230 because they've gone beyond just trying to moderate for illegal activity on the platforms? They've gone into outright editorializing and called it viewpoint discrimination, to the point where now they are acting as publishers. And it was a 1950s Supreme Court decision, from what I understood, was a bookstore in LA was held liable for defamatory content in one of the books it was selling, and something along those lines. And the Supreme Court said, no, it's a bookstore can't possibly be held liable for the content of every book that they're selling. And there was the analogy I gave actually in my video last week, before I had even known the Supreme Court decision existed. And the analogy can somewhat fail if and when, you know, the book gets served with a cease and desist, or a don't sell this book or pull it from your shelves because it contains defamatory statements. If the bookstore doesn't do it then they can become liable themselves when they knew or ought to have known or were negligent in not knowing. But the rule was that you don't hold the newspaper stand liable for the contents of the newspapers. And so the question now is there such curating going on with these massive platforms to the point where it's no longer moderation but actual editorializing, that they should lose their immunity, which was provided to protect them from doing the right thing, not to protect them in becoming politically biased platforms that discriminate based on ideologies. It was Ted. So Senator Ted posted that video. I want to see if YouTube takes his down. Should be fun to watch what happens. Yeah, so apparently apparently the Project Veritas video itself was pulled from YouTube and Google. And apparently Ted Cruz posted it on his own web hosting platform. Sort of a thumb in the nose, and we'll see where it goes. It's very interesting. So that's Crenshaw. What's the guy's name? You know who I'm thinking about. He was the one who was grilling the Facebook execs on how they referred to certain users, Ben Shapiro in particular. Okay, I can't remember his name. Crenshaw. Did we discuss what his name was? And so Senator Hawley, and let me get the provisions of it, has proposed an amendment to Bill 30, which would basically require platforms with more than 30 million users in America, 300 million users worldwide. I think it's more than 500 million in revenue, with certain thresholds, basically big platforms who may be guilty of curating and editorializing more so than moderating, which was what 230 was supposed to protect. Basically saying they have to go through a certification. They have to provide evidence that their algorithms are neutral and not viewpoint based, that they're not actually discriminating based on ideologies or political leanings, but that they're applying rules fairly to everybody. I mean, there are criteria set out in the proposed bill, but it's obvious that they're going for the Facebook, YouTube, Twitter, and those platforms. So that's what the proposed modification is. It's a very interesting concept. A certification that's good for 2 years. Show us the systems, show us the methodology, and you'll get immunity under Section 230. But to the extent now that you have reports, which you can question the reports all you want. I mean, I know a lot of people don't think Project Veritas is particularly credible, that they engage in selective editing themselves. I know people think that. I know other people think it's the last standing investigative journalists and journalism out there. So you can attack the source to some extent, but at the end of the day, the question, and I see it in the comment section of my videos, is even left-leaning people who are overtly and openly left-leaning saying we're getting fed up with this because it's just ruining everything. So the idea is you get a 2-year certification, transparency, show that your algorithm, your editorial, your moderation is not politically inclined, politically biased, that it's not dedicated to ensuring that certain people don't come to power and others do, and you get the protection under Section 230. If you don't, then you lose the protection under 230. And it's an interesting thing is that to some extent, if the moderation is in fact curating and in fact so selective that it constitutes editorializing, why shouldn't they then be held liable for what they do leave on the platform? But it's going to be interesting to see. It's coming to a head. It's coming to a head fast because there is I see it. I'm on the internet world. There's a sentiment among the left and the right that these big tech companies are they're sucking and blowing. They're reaping the benefits while incurring none of the exposure, and they carry themselves potentially like. The funniest thing was when Ted Cruz was grilling, I forget who it was from Google or YouTube, and the person said, well, she says, I have a day job, so I didn't read the report and I didn't watch the video. And Ted Cruz is like, I'm sorry, these congressional hearings on commerce are getting in the way with your day job. It was such a bad answer and such a jab to say, like, yeah, I'm sorry, you're in front of Congress, in front of the entire nation, talking about whether or not you're potentially on the verge of losing immunity under Section 230 as a platform, and we're sorry to get in the way of your day job. So that's where the Section 230 is. We're going to see where it's going to go because my prediction is there's going to be some radical changes sooner than later because the evolution of the internet is protections. What was set up to be protection back in the day has become potentially abused in the current day, and the real risk also is it's not like anybody wants the government coming in and deciding who's being neutral in their algorithm. And this is where like you can see things not through political lines. It doesn't matter who's in charge. The fact is you're going to have one political party in charge with their political appointees, presumably on the commission, deciding on whether or not the algorithm is objective. And the other thing is like, tech companies are not above the law, and there's no but to that. There is the nuance that congressmen are congressmen and tech people are tech people, and it is, and I say this from a lawyer's perspective, is it's very difficult sometimes to get a judge who's a judge to understand the nuances of high-tech stuff. Like, how does a judge or how does a congressman agree that the algorithm is politically neutral? How do you prove that it's politically neutral to a congressman? Is it purely results-oriented? Do you have to have equal shutdowns on both sides? So there's a whole bunch of problems that come into play even when you have the government determining what's objective, because the government has its own interests. So objective to someone with interests is not objective to all. And so that's it. Let me see if I can get the actual bill for Holly's bill. I know I sent it to myself this morning. Okay, that is the actual Section 230. Yeah, it's Holly's bill. So let me see. I sent it to myself by email. I know that for sure. Holly's Senate bill. Here we go. Okay, so the bill is called A Bill to Amend the Communications Decency Act to encourage providers of interactive computer services to provide content moderation that is politically neutral. It has to be a bipartisan bill for it to be reasonably politically neutral. But then the problem is, like, if you want to be cynical, you can have a bipartisan bill, but each party knows that when they are the ones appointing the commissioners, that it's, the way government and politics plays out. And let's get the criteria for what it was in terms of numbers of users. One day I'm going to figure out how to show you this screen while we do it, but the last time I tried, it didn't really work all that well. Oh, and they define politically neutral, certification, approval, publication. It's a very interesting bill. You know what? Let me I'll post a link in the comment section so that you can all read it, because it's actually quite good. And I'll post it in the comment, not in the chat, but in the comment section, and pin the comment so everybody can read it. It's very interesting. It's a good bill. It's well drafted, and it's thought out, and it sets out the mechanisms that this would be done for. But we'll see. I think it's coming sooner than later. Tony C, appreciate what you do. Thank you very much. Chris Lieb says, read Project Veritas's letter to Congress, claims Google in violation of federal election laws. We'll see where it's going. I mean, this is these are very, very important issues, especially if you have the reports coming out. I know I saw the Project Veritas report. I know what the leaker or the whistleblower says. It always becomes a question. You have to look at it very analytically and say, when someone says something, do they have knowledge of it? Are they expressing their own opinion? Are they revealing an internal problem, or are they? Nothing can be taken at face value, but when you have a number of things adding up, you can start, coming to your own conclusions. But it looks like the proposal to the proposed amendment to Section 230 looks interesting, looks decent. The risk is you take the power and immunity out of the tech giants and you give it to the government, and that carries with it its own risks. But there is no system that's perfect. It's just the least imperfect, the most imperfect system that we should go for. Chaos Minor says SJWs hate free speech. They love Google. I'm only reading that not to approve of the message. It's Chaos Minor. Okay, anyways, everyone can see that anyhow. But it's the free speech is an interesting thing. I still haven't done my video on our human rights tribunals, because there's free speech. Freedom has to be exercised with a certain degree of caution. But it's not a question of people hating free speech. It is a question of the world being super politically charged, where people want to silence their political and ideological adversaries. Okay, what else do we talk about? So we did Section 230. We did the history of Section 230, which is just it's a very big overview. We did where it's going to go. What were the other vlogs we did this week? We did FUCT. Let me just go to my channel and see what the other. If it looks like I'm sweating, by the way, it's because it's ridiculously hot and humid in Montreal today. Let's see what we got here. Videos. Okay, we did defamed by YouTube. Oh yes, they removed my video. Let's talk about that, because that's a funny one. YouTube, that whole saga of YouTube removing the video, demonetizing the video, confirming it on appeal, removing the video, confirming it on appeal. Ted Cruz grills a Google exec the day after the video's back up on YouTube without me having asked or re-appealed. And the day after that, the video's remonetized and I get a confirmation email without me having asked or re-appealed. It's and some of the things like, I always thought manual review was actually done by a person, and maybe I was totally naive and stupid to think that. I'm convinced there's no people doing this. And what I'm realizing about all of this is it definitely looks like there's political bias ingrained in the algorithm. I'd say that, but that might just be a question of my own perspective and seeing which of my videos have been flagged and which haven't. Thus far, the videos that have gotten me demonetized on YouTube were anything which I still consider it neutral to be dealing with Julian Assange, Nicholas Sandman, and AJ, he whose name can't be named. I don't even know how if they've changed the algorithm. No, I mean, I'll repeat it, but those videos were pure law videos. No opinion, no rhetoric, no analyzing, and certainly no justifying any conspiracy theories among any of them, because there's a ton of theories with Assange, there's a ton of theories with Jones. Sandman, there's not a ton of theories, it's just a ton of vitriol, but none of them were about that. So those are the three videos, those are the three subjects of videos that I've noticed got flagged. That and my penises of the Met got flagged, but I understand why. I mean, okay, I think it's art. YouTube thinks it's improper. Now, is that political? I mean, or are they just setting up words that nail in the algorithm, that just nail certain types of videos? But what I noticed, and for the people who want to play that thought experiment, other videos that don't get pulled and don't get demonetized from other channels and other mainstream outlets might lend you to believe that it's sort of not entirely a result of a problem in the algorithm, but potentially something else. But I mean, and this is where, like, it's nice to have an opinion, and I certainly have my own opinion, but there's no point having an opinion when we can all agree on the bottom line. The bottom line is the algorithm is broken. It's either broken deliberately because of political bias, as you know, some believe as a result of undercover whistleblowing. It's either broken just because it's broken because, you know, you put in certain words and you have a robot deciding what videos get pulled and demonetized. But so I mean, that whole thing with my video, what really irked me about it, and I love to think that I have such power and intimidation power as an attorney and influence as a YouTuber, that someone at YouTube or Google saw my video, should I sue YouTube for defamation, and realize the error in their ways and the consequences of suggesting that something constitutes hate speech, and decided to put my video back up and remonetize it. I'd love to believe that. I just think it's someone went and tinkered with an algorithm and then lo and behold, it searched the internet and put it back up. But what really I mean, irked me about that, and I'm not saying it to be dramatic, hate speech, but whether or not you believe that it's a thing, and I've seen Crowder's hate speech doesn't exist, and I know our courts in Canada recognize hate speech. Whether or not you believe it exists, it has very serious consequences to suggest that someone engages in it. Because even if you don't believe it exists, I mean, we can conceive of what hate speech is as a concept, and it involves saying hateful things about people. Well, and you know, when it comes to Crowder, it's not that my opinion would be that hate speech doesn't exist. The fundamental question is, hate speech exists because love speech exists, hate speech exists. The only question is really, should it be illegalized and criminalized and legislated against and restricted by the government? That's the real question. But when an entity and a platform suggests that people are engaging in hate speech, or their channel violates the terms of service as relates to hate speech, I don't think people really actually stop to think about the implications that carries with it. Now, plugging Eric Hunley's podcast that I just did with him, and I sent a link for the first half. We did a follow-up yesterday because of what happened on YouTube. Check it out. It's Eric Hunley, Unstructured. And I actually listened to the entire podcast. It was good. It's nice listening to me talk. I do find I stutter or hem and haw sometimes, maybe a little too much, but that's only a force of habit of having to always hear what I say before I say it, to see if someone is going to misinterpret it and use it against me in the future. Improperly use it against me in the future. I have no problem anyone properly using things I've said against me in the future. Now, what I've done, I've confused myself. So we were talking about the podcast. We were talking about the hate speech. That's it. Okay. And JP says no speech should be restricted. No. And I appreciate that. And this is the nuance that's going to come when I break down this decision, Mike Ward versus this kid who sued him. I can understand and feel both sides, although I have my opinion on it. And I've said it before, free speech, imperfect free speech is better than perfect censorship. When YouTube suggests as a reason for having taken down a video or shut down a channel that it's because it violated terms of use as relates to hate speech, I think they see it as an administrative label without actually appreciating that it is a libelous statement. And I'm not saying that to be inflammatory. I'm not saying that to be dramatic. I consider it libelous to wrongly suggest that someone engages in hate speech. Whether or not you believe it exists, whether or not you believe it should be legal or illegal. It is libelous to wrongly suggest that someone is engaging in hate speech. And not only is it wrong, and not only is it libelous, but it creates this precedent where even if it was wrong in the first place, and it was objectively wrong in my place, so much so that the video was republished and remonetized, but it creates that doubt, and it creates that moment in time where someone can always say, Viva Frei had a video taken down because it violated the terms of service as relates to hate speech. And I mean, these things don't disappear, and not everyone is as fortunate as the happenstance or the whatever fluke occurred that I was, what's the word I want to say? I want to say that I was vindicated, but like not everyone's video comes back up, and then it leaves a tarnish and it leaves ammunition for people who hate that person to abuse of that mischaracterization for nefarious purposes. And I think, to the extent that these platforms want immunity in their moderation, when they engage in that type of subjective curation, I don't see why they should benefit from the immunity under Section 230 to wrongly suggest that some of their users are engaging in hate speech. And it's almost like, take it down and don't give a libelous justification as to why. And certainly don't give a libelous justification based on a very subjective interpretation of terms of service that are themselves incomprehensible and purely subjective and fluid and change from one day to the next and are modified over time. What is hate speech by the terms of service standards in a month is not necessarily going to be what was hate speech a year ago when the video was posted. So that's it. I mean, I was livid when I actually saw that. I don't think I was ever seriously contemplating suing YouTube. I think it's a good warning for them to take from this, because I don't think that should just be an acceptable standard to suggest that someone's video was taken down because it violated terms of service as relates to hate speech. I don't think it's an acceptable standard, and I think it should be changed ASAP. Okay, let's see what we got here. Any questions in? Ginny Thompson, Redwall, modify even worse. Okay, so I can't come into a comment section halfway in. Sorry, a discussion halfway in. Ask some questions if anybody has any questions. Off topic, anything, we'll do this. We're nearing, I got like maybe 14 minutes left, and we'll see when I hear that doorbell or the door ring. But I mean, I watch Tim Pool a lot, and I watch the Young Turks, and it's just an interesting thing as to who gets the hammer for what's deemed to be offensive content and who doesn't. And I've seen some stuff that I consider to be tremendously offensive on the Young Turks, and it's not to say that it should be banned. It's not to say that they should be shut down or labeled as hate speech. It's, first, I'm old school. Sticks and stones can break my bones, and certainly it becomes a very slippery slope when you say what someone can say about someone versus what they can't. And I always draw my line at the incitement of violence. I mean, that's where I draw my line. But the problem is, and I can, as a lawyer and knowing the way lawyers rationalize, one can say, even using certain terms which themselves are not overt or even direct incitements to violence, constitute incitement to violence. Which is what, can someone remind me of what the congressman who was grilling Google, what his name was, Crenshaw? Got to do it. So it's what I loved in his reasoning when he was referring to how it is that Facebook can refer to Ben Shapiro as the new, as what they refer to them as. Crenshaw. Okay, good. Thank you. And he says, calling someone the World War II slur, the German World War II slur, some people can consider that an incitement to violence, especially given the trends that are going around in terms of, punch a blank. But so you have, I draw the line at incitement to violence or violence, period. Then the question is, you can get creative thought processes and say, well, using this term is incitement to violence and using this term is incitement to violence when it is in fact not. And that's the whole irony of these gags and these what's the word? Not jokes, but these things that have happened where memes become associated with things that they never were intended to be associated with. These jokes that go too far, and then people actually start equating absolutely non-violent things with inciting violence, and that's where you start abusing of terminology to silence your political adversaries. So that's it. I mean, my video was somewhat serious because I did have the thought, but I'm not suing anybody really, because I know what the process is like. Also, it's all a war, and I wouldn't expect anyone to go easy on me in the warfare that is litigation. And you have to have a very good reason and you have to make a decision that that's what you're going to do, and it has to be something serious enough to justify doing it. What else? But it's fun. It's funny. My channel is definitely, I'm not going to turn into a channel that does this just because it becomes self-referential and boring and tedious. But I had to do a follow-up on the initial video just because it was so hilarious the way things went down, the timing of the way things went down, and just the way it was playing out in my head as well. Like very funny. Okay, let's see what we got here. Any update on the Covington lawsuit? To my knowledge, there's been no update on the Covington lawsuit. I don't know when depositions are. I was Googling it the other day just to find out. I wanted to know what happened to Washington Post's motion to dismiss. Oh wait, no, I think I do know what happened to that. I don't even think they got a hearing on the motion to dismiss. Anyways, I don't know. There hasn't been much update in that. Jussie Smollett, from a legal perspective, I've got nothing more to add. I mean, I'm not going to do a vlog on it just because it's a trending subject when I have nothing more to add or nothing insightful to add from a legal perspective. Everything that's going on in that file right now is, I won't say gossip, but it's political in its opinion right now, but everyone pretty much has the same opinion on what's going on with that. Dan Crenshaw, almost at 100,000 film view. It's so cool to think that I'm almost at 100,000. First of all, it's idolatry. I agree and I accept that it is idolatry. It's just a big milestone, and that silver play button would feel nice to get. But I accept that it is vanity. It is superficiality of the human condition to want a trophy. The only reason why it represents something is the work that's gone into this, and the day in and the day out, and trying to turn this into a sustainable, call it a business, but trying to turn this into something sustainable because I love doing it. I mean, I love doing it. J.D. Thompson says, the problem isn't the speech, the problem is the apparent lack of ability of the hearers to discern opinion from fact. You should all listen to Eric Hunley's, the podcast I did with Eric Hunley, and incidentally, the other one was with Andrew Curtis. So I did another one with the Andrew Curtis Show. So check out the Andrew Curtis Show. I'd say the Andrew Curtis Show podcast was a little less, I would say political, but it was a little less focused on issues of the channel than Eric Hunley. But Eric Hunley and I, on Unstructured, had this discussion. And it's not a question of people not hearing. It's just that we're being conditioned, politically, not to be looking for common ground and not to be looking for mutual solutions, but rather looking for victory at all costs. That is the state of politics now. It probably was always the state of politics, but before social media connected literally everyone on earth, that party divisiveness was limited to Washington geographically and spiritually. Now, it's national and it's international. So it's not a question of people hearing, but it's just a question of people want to win the ideological debate without genuinely trying to understand the other person. And that's the thing that people just are veering away from, to a point where it's causing a cultural, sociological divide. The inability to tolerate someone else's opinions when they differ from one of your core beliefs. So that's it. Let's see what we got here. Kiwi Bloke says, thought to commit a crime isn't a crime, but expressing your intent to commit a crime is, can be in conspiracy. Yeah, well, I mean, everyone has to appreciate that there are limitations on freedom of speech. It's just, where is that limitation? You have defamation as a limitation of freedom of speech under the law, civilly, and you have uttering of threats, which is effectively limited free speech in a criminal sense. But that's it. Let's see. Here we go. With 3 steps sideways says, not a great deal of room to form a 50 slots. I don't know what that means. Yosemite Sam says, you are so good at it, the Legal Eagle just drips partisanship. I like Legal Eagle. I mean, I'll say this all the time. I do like him. I do. It is interesting that you can predict where his analysis is going to go. And that's good indication that you can get a feel for not only someone's political ideology or partisanship, but the way it influences their interpretation of facts. I like to think I can dissociate myself so much from my own opinion that I could accurately depict the other side, even if I so vehemently disagree with it. And I think I can, only because it's the mental exercise. It's like playing chess against yourself, where you say, okay, I know what move I would do if I were the other side to beat me. So it's just a mental exercise. I may never agree with someone, but I could probably argue their position, more strongly than they can. Let's see if we got any questions here. 3 steps sideways says, Viva, we can't ask questions in Super Chat properly. Only room for 50 characters. Oh, I see what you're saying. Okay. Let's see what we got here. Everyone is politically, Salad Von Bako, I remember that name from a long time. Everyone is politically motivated, even if they don't think they are. I see your political leanings in your vlog. Well, what do you think my political leanings are? Political. What do you think my opinions are? The thing is this, I'm not shy to express my opinions, but the only reason why it becomes useless and almost irrelevant or almost destructive to voice the opinions is it just allows people who disagree with you to delegitimize your opinion based on accusations of politics. And it's the interesting thing is most people don't want to know your opinion because they genuinely want to know your opinion. They want to know your opinion so they can either justify why they agree with you, or so that they can attack and undermine your opinion based on your politics and your opinion. So they'll attack the interpretation based on the opinion of the person. And that's generally why opinions are of interest to other people. And so that's it. It's I have my opinions. It's just I also don't find that it goes anywhere. You end up, the fights you're going to get into with the people who don't share your opinion, and the approval you're going to get from people who do share your opinion. Let's see here. So Jonas D. Atlas says, so basically people only ask your opinion to be vindicated in their own. It might be an oversimplification, but it's sort of my impression is that people want to know your opinion because if they like you and they respect you and they feel the same way, then it sort of affirms their own beliefs. If they want to find a reason to dislike you and to undermine your opinion, undermine your analysis, then they can attack you based on your opinion. Or they can at least attack your analysis based on their perception of your opinion. But all I'd say is that Legal definitely gives strong indications as to his political leanings. And I remembered seeing it in his analysis of the Mueller report, so much so to the point where I began to question my analysis of the Mueller report because we were differing on what I felt were like fundamental points, which was we were different on fundamental points of the actual report, which was, why was the obstruction, why was the indictment or the prohibition of indicting a sitting president only discussed in the obstruction, but not in the actual collusion? And I still believe my opinion, but I was questioning how he got to his conclusions. I also, on the Kavanaugh hearings and on his assessment of direct evidence coming by way of testimonial evidence, that 30 plus year old testimonial evidence is not, I wouldn't qualify as direct evidence. And I thought, there was some opinion influencing interpretation there. But then again, I'm doing exactly what I was not criticizing, but what I was suggesting happens is when you think you know someone else's opinion, you begin to interpret their analyses based on your understanding of their opinion, which is why I try to be neutral in my opinion, but also neutral in my analyses. Okay, let's see what we got here. Creven Strouder. Oh, for a second, I thought Steven Crowder was here. Creven Strouder says, hey, Frei, I'd love to hear your thoughts on the Florida Bill HB 741 limiting the First Amendment. I would have to look into it, do some research on it, understand what it is before doing it, but I'll put it on my list. Let's see what we got here. Sarah Bellum says, time to put the baby to bed. Have a good one. Bye, Sarah. I don't know what time it is where you are, so maybe it's a nap time, but Sarah, good to see you again. Dusty Daniel says, enjoy your vlogs, pal. What are your thoughts on the liberals calling this a white supremacy remark? Never heard of that myself growing up. No, I think that was one of the 4chan gags that actually got traction. And then it became like, from what I understand, that was started as a joke on 4chan to make it innocuous symbol, one that everyone does in ordinary gesticulation, and make it into a hate symbol so that people would then accuse others of doing it. Now I'm nervous about what to do with my hands, but accuse others of doing it as evidence of white supremacy. But then the whole joke was, Tim Pool was pointing this out too, you have Alexandria Ocasio-Cortez doing it, you have everybody doing it because it's like almost a reflexive thing. And growing up, we used to do the thing where like people would do that symbol, and if someone looked at it, you'd put it below your waist, and if someone looked at it, you'd punch them. That was the whole gag. And so they turned an innocuous, commonly used hand gesture, and people ran with it. Mainstream media ran with it because of this need to demonize adversaries and turn non-violent, non-offensive issues, symbols, gestures into offensive ones for political gain. Yeah, that was madness. Read about Viva. It was a game started in the 80s. Yeah, okay, no, I think that's what I hope that's what I just said. But like, man, I grew up with that. You put it below someone's waist, and they punch you. You punch what they looked at it. So like a blue punch buggy. Yosemite Sam says, on his Kavanaugh hearings, he assumed Kavanaugh was lying. It was obvious. Well, I don't know about that, but like I did a video on the Kavanaugh hearings. I mean, this was before my vlogs became relatively popular. Go check it out, because I did one on that. And some people are going to hate me. Some people on both sides are going to hate me because it was a question of playing the mental exercise of making the best arguments in support of Kavanaugh, or trying to understand what could on its face be seen as an injustice to Kavanaugh. And then it's also like playing a thought experiment. Why would anyone wait 35 years before coming out with these types of accusations. And you could, I can make the arguments from both sides. And this is where, you know, opinion becomes, opinion is relevant if you're sitting down over dinner or over coffee with someone to have a nuanced discussion where you can properly express your opinions. Social media is not the place for that. It just leads to the, you know, when you cook and you reduce sugar, or you reduce something to like a thick syrup. I mean, that's what happens with dialogue on the internet, on social media. There's no nuanced discussion. You're reducing everything to like a sludge, and that's what rhetoric becomes on YouTube when it deals with discussions that need to be done in person, when you can see faces, look into eyes, hear inflection. Let's see what we got here. Okay. Scott MC says, I still think it was frivolous. All coffee is 220 220 Fahrenheit at first. McDonald's is hotter because it's fresher. Scott MC is presumably talking about my McDonald's lawsuit. You know what? And I can understand people thinking it's frivolous. Even if you think it's frivolous, McDonald's had a number of complaints and could have settled the lawsuit for only what the woman was asking for. And so there you have a question where, in French, we have that expression, pourquoi mourir pour une cause? Like, why die for one cause when there are so many? You have McDonald's saying, we're drawing our line in the sand, and we're saying we're not compensating you. But you can't argue with the fact that if you have enough car accidents, you have to look into it. If you have enough incidents where people are getting scalded by coffee, you have to look into it. Maybe it's not a question of like making the warning bigger, but they did make their cups more rigid. And so you can get stubborn and say I'm right, and therefore I'm not even looking at it because you're an idiot if you expect coffee not to be hot. Or you can look for a solution, and you can pay the lady, a 78-year-old lady, the $15,000 she was asking for medical services, but they didn't. Let's see what we got here. Okay. Tommy Stewart says, I had no idea it was so much more complicated than the mainstream media story. One of my favorite videos you've done. Thank you. You know, and it's funny, nobody knows. No, educated people do not know the nuances to that story. I didn't know that. As a lawyer, I didn't know the nuances until I looked into it to do this public speaking competition that I did. Okay, so let's see what else. Who else has got some questions here? JP says, I'd like to hear your opinion one of these days on the recent social media regulation legislation. Hold on, I think we may have touched on that, but you can always bet that legislation is a last resort to solving a problem, because legislation is just one more thing for judges to interpret and potentially get wrong. It's just the way things work. It's the same thing I say in contracts all the time. A longer contract is not a better contract. It just gives more ammunition to misinterpret, either intentionally or unintentionally. So everyone's saying, yeah, why would Kiwi Bloke says, why would I put that between my knees? These are the things. Now, this is another thing, is that sometimes the consequences of an act of stupidity can be so disproportionately devastating. It is silly to put coffee between your legs, but if the coffee is so darn hot that it causes your clothes to melt to your skin, maybe there are other compounding problems to the initial silliness. But anyways, my opinion on that is it was not as frivolous as it was. And it was an interesting decision on the substance. Okay, let's see what else we got. How much time do we have left here? Okay, so let's take some questions. Whoever has any questions, start getting them in now, and we'll call this in a few minutes. What do I think of Prime Minister Trudeau? That would be a pure opinion question that one would only want to know in order to establish political leanings. Full disclosure, I'm fairly certain I voted for all political. I think I just saw a hummingbird. Oh, look at me. I'm joking. That's an old joke to change the subject. Trudeau's going to be in trouble. This is a pure opinion, but Trudeau's going to have some answers to give. He's going to have his day of reckoning in the re-election based on what happened with our Attorney General, and that is not a partisan statement. That is objective. I don't like any politicians disregarding opinions of their citizens and their constituents. And there were a number of videos of Trudeau, in my opinion, not dealing with his constituents, with even people who didn't vote for him, not dealing with people respectfully. And I mean, the most amazing, I mean, one of the most hilarious in a very cynical sense was when he sarcastically thanked a Native American protester for her donation to the party when there was some fundraiser and the person to protest Native issues, which are real issues that the government has really not done any meaningful, not done enough to deal with. bought a ticket, obviously, to get into the fundraiser to then protest in front of the Prime Minister. And the Prime Minister sarcastically and tongue-in-cheek and very sassily said, "Thank you very much for your donation," as the protester was being escorted out. You can be liberal, you can vote liberal, and still say that that's not the way any politician should act. And you can be Republican, and you can say that, you know, certain tweets are not the way any president should tweet. These are not partisan issues. They don't have to be partisan issues. But the election is going to be very interesting. It's going to be very interesting because there's a lot of ammunition to make for interesting politics, as interesting as Canadian politics can get. What do I think about the creepy Joe Biden videos? Yeah, that's an interesting one. If anyone, there's some videos in there. There's some things that context can't necessarily explain, but I think the amazing Lucas and I touched on this. Maybe we didn't, but no, there's some things in there that people have different thresholds for what they think is appropriate. But there's stuff in there that I don't think is appropriate. But again, you have your own opinion. These are things that are purely opinion based. I think a lot of people, the majority of people, think that it is questionable, or at the very least a little bizarre. Whether or not it's, you know, generational, it can be someone's political or partisan justification for it. But yeah, you know, I have kids, and I know how I would react if I saw some of those things. Let's see what we got here. Any thoughts on Grab Her case in Nova Scotia? That's the license plate that was taken away because it was deemed to be offensive. It seems a little excessive. When I saw it the first time, I didn't even read it as Grab Her, and I think that I don't know what the state of that of contestation or appeal is, but it's like, you know, the movie Meet the Fockers. From what I understood, here we did FUCT, and now we're doing Fockers in this video. From what I understood, they couldn't get authorization for that movie title until they actually established that Focker was a legitimate last name, and not just a cheap gag. That's not just a cheap gag. So I think it's a little silly. I can totally understand the person's name and they want to have their license plate, and I don't think that there's an expression, "Oni soit qui mal y pense," or Latin expression, "Oni soit qui mal y pense." Oni soit qui mal y pense. Shame on he or she who has the improper thoughts to begin with. I wouldn't have looked at that license plate and ever seen Grab Her. I swear to you. So, yeah, it took me a second to even realize what the controversy was with that. Okay, let's see what we got here. Kiwi Bloke says, common sense must always be a fallback position for good decision making. Okay, it should be the fallback, starting point, and middle ground. What do you think about Trump targeting Huawei to further his goals against China? See, now, as a lawyer, I'm going to read that question, and I say, what do I think about Trump targeting Huawei? Now, the term targeting would imply an unfair singling out, and the second half, to further his goals against China, would also imply an intent. So I don't know about the intent, and I don't know about the intention behind targeting. There are legitimate issues there are legitimate national security issues with these things. I mean, it's the only question is, again, you know, going back to the unequal application of rules and laws, and when it becomes selective, it becomes susceptible. I left a Red Bull in the freezer. Hold on. Oh boy. Yeah. Oh, okay. Well, that's going to be frozen for sure. I'm going to wait a few minutes for that. You see, Nick Recchietta does the midnight live stream with whiskey, and I'm just going to do the midday live stream with a Red Bull. Yeah, I think there's issues. There's issues that need to be looked into, and we have similar concerns. We have similar concerns about foreign influence in our government and economics. Okay, let's see where we go down here. What is the healthcare like in Canada? This is interesting, W. Ward. This is a topic that I was actually going to do. I'm still going to do a video on it because people, you know, all say, and as much as they say that there's no free speech in Canada and the States, everyone says, oh, the States has free healthcare. So, and I have to double check my math and see that the logic is actually accurate, but I think healthcare budget is like 22% of our national budget, give or take. And so that is to say that 22% of every tax dollar we pay goes to healthcare, to fund free healthcare. And that's to say, if you make if your family, let's just take a single citizen, because you get tax benefits if you have two $50,000 income parents. But if you make $100,000 and you pay in Canada $45,000 in tax, That's to say then 20% of that 45,000 is going to healthcare, free healthcare, whether you use it or not. So it's free in the sense that you get to go and you can go wait for 6 hours in line if you have an issue when you need it, but it's not free in the sense that it's a substantial portion of every tax dollar we pay to the government. Is it 22 cents funds free healthcare? So I mean, that's the joke. It's not free. It's open and available when you need it, and it doesn't bankrupt families who need certain care. The flip side is that sometimes the care is so bad and so delayed that people end up going to the States with private healthcare to get top tier and timely healthcare in the States because it just doesn't happen here. And you have the horror stories. I mean, you have the horror stories everywhere, which is why the horror stories don't make for legitimate representation of the system. But you have horror stories of people dying in the waiting room, as you do you have them everywhere, and they don't reflect the essence of the system, but they do certainly make for the headlines as to how bad and how long the waits are. I went, let me think of some good examples. I separated my shoulder when I was 15 years ago, and I waited in the hospital for 8 to 10 hours. My father had to come, like jokingly try to get me seen, but they're not seeing someone with a separated shoulder without a head injury before they see the people with the head injury. And then you wait. I mean, you can't find GPs. You wait for months to get appointments. So free, it's not free, and you pay for it even if you don't use it. It's good, and it's certainly, for a country of 30, I think we're 36 million now, it works. Then the question is, is it scalable? Can it work in a country of 350 million? Can it work in a country of 1.6 billion? And can it work with a degree of efficiency? That's my take on it. I'll probably do a video on it because the comparative state of the healthcare in Canada, unfortunately, I have to know how it works in the States a little bit more than I do. But okay, so let's see here. Socialized medicine has its good and bad points, undoubtedly. And the other thing is, like in Canada, everybody talks about how cheap the same medicines are that are an arm and a leg in the States. And there's the reality of the size of the markets and who has to finance in like the economic sense, the R&D that goes into the discovery of these medicines. And so everybody says, oh, you can come up to Canada and get the same medicines for cheaper, but you're dealing with a market that's smaller than California, an entire nation. And so these things, the questions are just not the same questions, and the solutions are not the same solutions, if only because of the scale and the power and the influence of the markets. Okay, that's what we got here. Okay, there's definitely some portion of the conversation I will not be getting involved with. Can you purchase antibiotics over the counter? No. You need a prescription for that. Chris Lieb. Will you make a giant cake with an ostrich egg? That would not be a bad 100,000 sub special. And the ostrich farm is open for business. I want to do a vlog in that ostrich farm to know what permits they had to get in order to do that, where, how it works. One thing, and it's coming also, these are all things on the back burner, is doing business in Quebec is an interesting subject for anybody, and we're gonna go until my wife gets back. And when I hear the door open, we'll close up. Doing business in Quebec, for anybody who doesn't know, is tremendously complicated because we have language laws. We have our Bill 101, which for anybody who doesn't know what it is, means that you have to have French on every product. And so you have to have French, and you can have French and English, or you can have French and other on every product that's sold in Quebec. And an anecdote from the practice is I knew someone who delivered products, food products, and they were from out of the province, and they didn't have French labels on them. There was only English, and so by law they got a visit from the language police, as we literally call them here, and they said, you need to have French on this. Okay, fine. So the person, to add an extra cost of business, literally printed up. You have to contact the company, get them to translate, because you can't just do it yourself. Labels, which you then manually stick on all these products. And the language police got angry because it was measured in ounces, and the abbreviated term for ounces was not the French abbreviated term. That was what was sort of stamped onto the metal container. This is not an ad for Red Bull, by the way, but if they ever wanted to sponsor me, let's see if it's slush. That's my advice. This is stuff. It can't be good for you, but it tastes so darn good. And so they literally had to cover up the French abbreviated symbol for ounce to make it compliant. So it's interesting. Doing business in Quebec is a very interesting thing. So that might be an interesting vlog to expose to the rest of the world who doesn't know how our how our bilingual system works, or our, it's interesting. Okay, that's what we got here. Is this space only for your live streams, or do you still film and edit in your wife's closet? Will this wall be a more permanent addition to your videos? Who likes this more than the stenciling up in our walk-in closet? I do the walk-in closet just because the dogs make noise, the dishwasher makes noise, and it's a quiet spot, and I like the lighting. But I can do this backdrop if anybody likes it more. Slush Red Bull is too funny. Yeah, it's a Red Bull. It's a Red Bull slushie. Okay, so let's see what we got here. My total cost for insulin is $0 without funding. It would be over $2,000 with current insulin prices here. Oh, look, and I have family in the States. I have a brother and a sister and their spouses and children, and I know about it. I mean, it's the prices without coverage are what's the word? There's a word for it. They are prohibitively expensive to the point where people can't get the care that they need. They can't get the medicine they need, which is obviously. It's obviously a problem. The causes of that problem are very complicated. And anybody want to say hi? No? Okay, whatever. The causes of that are closet. I just read one of the comments. Looks better than the closet. Michael Albert. Okay. Okay, so what else? Who's got any more questions? I like the fish fossil setting area. Yeah, that was a good one. That was where we had our temporary kitchen when the house was under construction. So yeah, the fossil board in the back was nice. Well, maybe I'll go back there. Okay, Tony, I'm not reading that comment. Okay, Mark C says the prices are cheaper per month than the cost of insurance for my wife, Viva. Yeah, and we got Anthony Oliveira says, I don't agree with 99% of what Alex Jones says, but would agree that Silicon Valley opened Pandora's box when they decided to censor him. I see many people complaining that YouTube is censoring. My major issue, especially knowing what Jones says, is that when you go and censor him, it's almost like you're validating the stuff that he says. I don't agree with laws that prohibit discussion on certain subjects. I say that once you censor somebody, you're not convincing anybody of anything except for the people who already believe it, and everybody else is sort of left wondering why if what he's saying is so outlandish and preposterous. Why even bother censoring it? And I understand the flip side to the argument is sometimes when you allow people to say certain things, it sort of creates its own momentum. And I appreciate that. And my only sentiment to that is when you censor them, you in fact increase that momentum, and it's called the Streisand effect. Sunlight is the greatest disinfectant. Open dialogue is the greatest disinfectant. And so censoring people, you're not resolving the problem. Hold on, Anonymous says, I still want you to answer my question. Are you talking to me or are you talking to someone in here? Okay, well that doesn't sound like me. 0 Hour TV says, hey David, how far do you run? Okay, by the way, let me just go ahead and give 0 Hour TV a shout out that he's working extremely hard to get fit, and he's been putting out daily videos about his journey. And I said, the daily videos are 1.5 minute. I said the real journey is going to be when you make a montage of all those videos and you go from day one, which was a year ago, to current day in a year. It's going to be beautiful. I run about 4.57 miles a day, not to be specific, but I run for 30 or 35 minutes at 8.1 miles an hour at 1.0 degree incline on the treadmill. That is my run. I don't sleep. I tend not to sleep well if I don't do my run. Okay, so that's it. But anyways, 0 Hour TV. Stick with it. It's not easy. I mean, especially when it's an uphill battle, literally, spiritually, physically. You'll get there. Okay, JP says, if YouTube kept a video down about AJ for hate speech, would you be the hero we need to pursue legal action? It would take a lot. I know what litigation is. I mean, it would take a lot for me to think. I mean, I don't know. It's a hypothetical. No, the reality is probably not, because you get into this realm where what are we going to do? I'm going to get in front of a judge and we're going to have a discussion. We're going to have a disagreement as to what hate speech is or what the terms of use are. It's a fundamental problem. I think more important than lawsuits are interesting and they make for great exposure, but sunlight is the greatest disinfectant. Getting that story out, getting my experience out with the results that I got, I think is probably more beneficial. It just takes enough people to do it. Viva is the hero we need, but not the hero we deserve. I love that expression, but thank you. That's maybe a little bit of an exaggeration, but I am but a person with a camera who likes making these videos. What do we got here? Thanks for the goal, brothers, TV. Godspeed, man. It's going to be good. Is YouTube a publisher since they pay for content? So that's another interesting thing about the 230 immunity. Is one of the criteria in some of the decisions was that, you know, if a platform pays its users to publish content, they're basically a publisher. And it's an interesting thing because, you know, it's not remuneration based on the content per se, but rather on a function of the views and the ad revenue. That would be a very interesting legal argument as a total side. That would be an interesting argument as a pure aside. Is it the type of remuneration that would make someone a publisher versus sort of like is AdSense remuneration? Is it royalties? Is it payment in that sense? I don't know. I mean, I think there's a good argument to say it's not like paying a contributor to a newspaper. It's not like New York Times paying its journalists. It's more like a function of the views, in which case it's not you have no guaranteed remuneration if there are no views on your video. So I think it's nuanced. But can YouTube be both a publisher and a platform? They pay into. Can they be both? No, I mean one encompasses the other. A publisher necessarily encompasses a platform, but not vice versa. I think once you go into one, it's not because you're a platform on one day that you're not a publisher because on that day you didn't publish. I think you can't be, you know, somewhat pregnant. Okay, so okay, let's see. I'm going to skip that one. I don't want to get into politics. Bruno 416. See, these are the questions. Religion and politics are useful only to assess everything else the person says, they become relevant factors when people invoke them to justify their opinion or to criticize somebody else's. So maybe that will be the day when those types of questions become relevant for my analyses. But yeah, for now, I don't hide anything. But these are not the things that I think are justifications for my opinions or bases for attacking others or, you know, analyzing others. So I would say it's irrelevant. Okay, so you have a census. Okay, hold on. Blessed Dunn says, my question is, what do you think of the SCOTUS decision on immigration? Legal question. Broad. It's a broad one. I don't know which question. I don't know which question on the immigration. And if it's the census question, I have to have more information and have to do a little more research in order to even present call it both sides, but in order to present that discussion. I just swallowed a lot of air on that one. Okay, what do we say? Okay, we're getting there. Let's go with 5 or 10 more questions, and then we're gonna close up, and everybody can go and enjoy the day. Any more videos with a squirrel with your GoPro? Okay, so let me just plug my other channel now, Viva Random. I put the GoPro, and I'm not saying this to just cover my tushy. When I walked into La Ronde, you know, I read all the restrictions, limitations, and there was nothing that said no cameras. They said no handheld devices and no loose objects. And so, okay, now the dog is letting me know that it's time. So I put the chest harness with the lock-in device under a shirt, and it's not falling off. It's not going anywhere. And I got the best POVs of the roller coasters in Montreal. And so check out, because I did a montage of all of them except the vampire, which was a separate video, but epic POVs. I want to get another squirrel video because my GoPro now is broken to the point where if it were to get lost, it would be an excuse to get a new one. I took the GoPro paintballing, and the GoPro was on my head and actually got shot by a paintball, and the LCD screen broke. So it still records, but I don't see the functions when it's recording. I'm going to do another squirrel video soon. Let's see what we got here. King Katura says, how do you find a lawyer to sue for big cases if you live in a rural area? Well, I mean, that's a big problem. I mean, in Canada, in the States, there's a market for big lawsuits where you'll find people to invest time and even more on contingency. It's a question of markets. Like, you know, You have less variety in smaller markets. It's a tough thing. Keith Wagner says, you make the day enjoyable. Enough said. Thank you very much. Do you support free speech for white supremacists to publicly try and convince people of their side? That question is only one to invite demonizing for any. I mean, it's a dangerous question only because the way the answer will be interpreted. I mean, it'll be the catch-all. I prefer imperfect free speech to perfect censorship. And that would be the answer to all these nuanced questions. But I'd have that discussion with anybody. Not privately, but not on a social media where people who would look at that question would only be looking at it for specific interests one way or the other. Okay, let me see here. Have you heard about the newest Veritas report? Yes, it depends which one we're looking at. Kiwi Bloke, can you do a video one day on the inherent rights of Indigenous peoples in cultivated countries as they pertain to Indigenous peoples' adherence to Commonwealth law without treaty or agreement? That's complicated, but that might come up in one of our videos. And incidentally, actually, tonight, for anyone who follows me on the other social media, I'm going to a mixed martial arts. It's called MTL Fight Night. It's a Montreal Fight Club. Barney, come here. There's a amateur fight night on the Oka Reserve, which is off the island of Montreal, and it's a native reserve where you can have these fights because in Quebec it's not yet legal to have these MMA fights. And there's a history to that. I did a video the last time I went, which sort of touched on the nature of the reserves versus cities and federal land versus native land. But no, I mean, that might come up sooner than later. It's an interesting topic. Alan Milan, how do you feel about Count Dankula, comedian, teaching his dog the salute and being convicted of a crime? That it can all. I think that may things. It's a tough thing. It's like I would not have reacted that way to that. I mean, now am I going to be guilty of a hate crime for not being egregious and thinking it was criminal what he did? But and that gets back to the similar type of laws we have in Canada where comedy, edgy comedy, or stuff that ordinarily back in the day, say if you don't like it, turn off the computer, turn off the TV, now can result in these types of orders. It's anyways, touchy. In New Zealand we have no reserves, only the Treaty of Waitangi, which I'd be interested in your opinion on as a legal document. Okay, I mean, I'm going to have to add that to the list of many things, but that might be. I'd have to. The learning curve on that would be exponential. Can you live stream the fight? I'm going to ask the organizers if I can live stream the fight. I know the guy who's putting on the fight, and he's the one who invited me to the last one. But I'll see if I can live stream a few minutes of it. I think I should be able to. Okay, let's do it. We call it. What time is it? 2:28. People, we are going to end this. I'm going to. Do you want to see Barney one last time before we go? Hey, Barney, come here. Come on, get over here. Get over here. 1, 2, 3. Oh, here he is. All right. Now let me see where we are on the framing of this. Barney, would you like to say goodbye and have a good weekend? So if that's not the cutest way to end a vlog, I don't know what is. People, peace out. Check out the next vlogs and spread the word. Let's get to 100,000. That would be wonderful. What would you say about that? It's amazing. On cue. This dog is the vlog dog. All right, guys. Have a good weekend. Talk to you soon.